It is our great pleasure to have the Honorable Kathleen O'Malley here today as our 2015 commencement speaker. She is a 1982 alumna and our only graduate serving as a federal appellate judge. Internationally renowned for her expertise in intellectual property law, Judge O'Malley is an active member of the law school's visiting committee, the chair of our Society of Benchers, and distinguished visiting jurist who has taught patent litigation courses to our students for many years. Judge O'Malley was appointed by President Barack Obama to the United States Court of Appeals for the Federal Circuit in 2010, after serving 16 years as a federal district court judge in the Northern District of Ohio. Please join us in welcoming one of our most distinguished graduates, Judge Kathleen O'Malley, as our 2015 commencement speaker.
Thank you, Dean Scharf, for your kind introduction, and thank you both Deans Scharf and Berg for your outstanding leadership of the Case Law School over these past few years. We all owe you a huge debt of gratitude, and I don't think that they ought to be left out of the applause. So I think we need to give them our thanks. And thank you, class of 2015, for making it to these crossroads today. It would have been really disappointing to be finally invited to speak at my alma mater's commencement without having an audience forced to listen to me. So, common wisdom is that the only thing graduates forget more quickly than the identity of their commencement speaker is the substance of the commencement address. And it's fine if you forget to attribute anything you might take away from today to me, but for the sake of what soon will be our shared profession, I hope that you will have a few takeaways from today that will stay with you, or at least that you will return to periodically over the years. Commencement's a funny word, simultaneously signaling ending and beginning. Now, you all know what's ending, your academic careers. There'll be no more classes, no more struggling with faulty exam software, no more Socratic method, and no more cramming all night for that one last test. And there will be no more study groups that sort of just happen to devolve into House of Cards or Game of Thrones marathons. No more house parties drinking beer and mulling over the rule against perpetuities. And no more I don't do class on Friday scheduling options. But what exactly is beginning? I know many of you probably feel a little less excited about what lies ahead than you did at your college graduation. Rather than imagine an uncertain and potentially exciting future, you're pretty sure what the near term holds, and you're not so sure how you feel about it. You're thinking about a summer of studying for the bar exam, continuing to look for or starting a new job that you know will be demanding, about repaying some student loans, and about making the parents, spouses, and significant others who sacrifice so much to get you to today proud. Many of you are having trouble seeing past these challenges. And I blame this, actually, in no small part, on the recent and somewhat boisterous public chorus proclaiming that young people should eschew law school in favor of more lucrative and less onerous professions, and that those who do not will be entering an uncertain legal marketplace with a trying future. Those voices, and the less than triumphant feeling they may be fomenting in you, are losing sight of an important fundamental truth. Lawyers have the unique ability to affect lives for the better, both individually and collectively. It is the legal profession and lawyers who comprise it who have been some of the most important agents of social change in recent history. And it is lawyers who have provided a voice for the disenfranchised, been among the strongest opponents of inequality and injustice, and been some of the staunchest defenders of those inalienable rights that form the structure of our republic. It's not just law schools that will suffer as fewer of your generation choose the legal profession. It is society as a whole and potentially the rule of law that are at risk. The dwindling size of the profession poses greater opportunities for each of you. But more importantly, it imposes a greater obligation on each of you to use your new craft to make a difference, to impact the world in which you live. Now, it was this promise of being in a position to affect lives, to affect change, that made me want to be not just a lawyer, but a federal judge. When I was 13, my family was heading to vacation on the Jersey Shore. In an era before podcasts and book downloads, we actually needed a hard copy book if we wanted to be entertained while lying on the beach. So I asked my brother, who was then 4 years my senior, for a beach read. Now, you need to understand that my brother Kevin, who would later go on to graduate from this very law school first in his class, was, even at 17, a little intense. Okay, well, I'll tell you if you don't tell him, he was actually kind of a nerd. So I said, you gotta keep this light. We're talking about a beach read here, and please avoid William Faulkner at all costs. That was his favorite author. So he gave me what he considered to be the closest thing to fluff in his library, a copy of Anthony Lewis's book, Gideon's Trumpet. It was the story of how a letter to the Supreme Court from a prisoner, Clarence Earl Gideon, led to a landmark decision, Gideon versus Wainwright. There, the Supreme Court declared that all defendants charged with felony offenses, whether in federal or state courts, must be provided counsel, even if they could not afford one. It turns out that several justices on the Supreme Court were waiting for a case to present the question squarely to the court, and that Mr. Gideon's letter asking why the state of Florida had refused to give him a lawyer presented the perfect vehicle through which they hoped to persuade their fellow justices to change the law. The Chief Justice appointed Abe Fortas, then a partner at a large DC firm, Arnold, Porter, and Fortas, to represent Mr. Gideon, and the course of criminal cases nationwide was forever altered. Now, the book about those events also altered my life, and not just because forever I will have a different view of what constitutes a beach read than I once did. I was impressed by the way that one simple set of facts, when presented to the right court at the right time with the help of the right lawyer, could change the lives of so many forever. Indeed, I was so impressed by this fact that I set my sights on becoming a lawyer and, though my parents thought I was a little insane at the time, and on becoming a federal judge. It was not the honor of the position or the opportunity to spend my days engaged in rigorous intellectual exercises that intrigued me, though I do appreciate those things now. It was the chance to make a real difference in people's lives. And I have had that opportunity in small ways and in big ones since graduating from here in 1982. I've had those opportunities both as a lawyer and as a judge. So my opportunities and my experiences have run the gamut from defending the First Amendment right of one single editorial cartoonist to criticize justices on the state Supreme Court, to redrawing electoral boundaries in the city of Euclid to protect the vote of the minorities in that community. In your day-to-day practice, you will also have the chance to impact lives in a very real way. You may find yourself defending a civil or criminal client, whether an individual or a corporation, wrongly accused of a tort, a crime, or a breach of contract. Or you may represent a plaintiff who has been injured or defrauded, or even whose patent has been infringed. By pouring your training into these clients, you will be making a real difference in their lives, and you will be doing an honor to your profession. But I urge you to go beyond your day-to-day challenges and professional satisfactions. I urge you to seek out and make yourself available to handle matters for which you may not be paid and which will not always make you popular. I urge you to use your training to alter the world around you. Now, let me give you a little historical perspective on important changes that lawyers have fostered, both on behalf of paying and pro bono clients, and tell you who some of those lawyers have been. Importantly, you will see that making money as a lawyer and making a difference are not mutually exclusive if you care enough to give of yourself. Individual liberties have been the essence of America since its founding. The drafters of the Declaration of Independence spoke of life, liberty, and the pursuit of happiness. And when some of our founding fathers recognized that the majoritarian structure of our government might leave individuals vulnerable to that majority, the Bill of Rights was crafted. Despite the founders' concerns, however, the early federal courts were hesitant to acknowledge the importance of what the Constitution guaranteed to the individual, or of the court's role in defending it. The Civil War and Civil War amendments it fosters could have led to a sea change, a movement toward protecting individual rights through the equal protection and due process clauses of the 14th Amendment. But the late 1800s and early 1900s were instead marked by a judiciary that was disinclined to protect individual liberties in the face of a contrary political will. The great promise of those Civil War amendments lay dormant. And things did not get that much better in the first half of the 20th century. In the face of FDR's exertion of strong executive power over the courts, it's perhaps not surprising that in Korematsu v. United States, the Supreme Court refused to prohibit the federal government from engaging in one of the most restrictive civil rights violations since slavery, the internment of Japanese Americans during World War II. It was lawyers who finally revived concern for individual civil rights and who convinced judicial officers that their obligation to interpret and enforce the individual rights guaranteed in the Constitution was both a very real and an independent one. In the 1940s and 1950s, Thurgood Marshall and the NAACP slowly had been convincing courts to strike down racial restrictions on higher education under the Equal Protection Clause. Through their dogged efforts, these lawyers found the ideal vehicle for addressing racial equality in education in Brown versus Board of Education. And there, the Supreme Court finally overturned the shameful separate but equal doctrine of Plessy versus Ferguson. Emboldened by these incremental changes and with the emergence of the Warren Court, a new era of protecting civil rights began, largely on the backs of attorneys willing to take on unpopular causes or to represent the oppressed. Over just a 15-year time frame, the legal landscape governing civil liberties changed, and not just with regard to racial inequality. In criminal law, the Supreme Court applied both the exclusionary rule and the right to avoid self-incrimination to the states, declared in Brady v. Maryland that prosecutors at all levels must disclose exculpatory evidence, and through both Miranda and Gideon, recognized a broad right to counsel. And the Supreme Court also recognized the right to personal privacy in Griswold versus Connecticut, the right for interracial couples to marry in Loving versus Virginia, and the importance of one person, one vote in Baker versus Carr and Reynolds versus Sims. Now, while Congress ultimately would support some of these reforms through advances like the Civil Rights Act of 1964, it was the courts and the lawyers that brought these and other cases that led the charge. Importantly, it has been lawyers of all types pushing society to recognize constitutional guarantees. Thurgood Marshall and those young lawyers at the NAACP fundamentally changed our notions of racial equality throughout the country. Sarah Weddington was a graduate of the University of Texas Law School who couldn't find a job. So instead, she joined forces with other graduate students to look for ways to challenge the anti-abortion statutes in Texas. She would go on to argue Roe versus Wade at age 26, still one of the youngest advocates to appear before the Supreme Court. Bernard Berkman was a young attorney for the ACLU when in 1961 he wrote an influential amicus brief in Mapp versus Ohio, the landmark case about the exclusionary rule. Though he had only acted as in an amicus capacity, he was permitted to argue his position before the Supreme Court, and that position prevailed. Recently, two well-known appellate advocates from two different large law firms, Ted Olson and David Boies, jointly challenged the constitutionality of Proposition 8, California's ban on same-sex marriage, and they did so on their own dime. And 10 lawyers from WilmerHale undertook the biggest pro bono effort in that firm's history when, with a 4-year legal struggle, they successfully convinced the Supreme Court to recognize the right of 6 Guantanamo detainees to seek writs of habeas corpus. In matters much closer to home, lawyers from Cleveland, some from Jones Day, spent years representing a death row defendant in a habeas matter completely free of charge. A few years ago, they finally were successful in getting Joe D'Ambrosio released from prison after convincing courts at all levels of the judiciary, including me, that Mr. D'Ambrosio had not been provided with a constitutionally fair trial when convicted of murder 20 years earlier. And my classmate from here at Case, Jim Woolley, has dedicated countless hours of his life, again at no charge, to helping Amanda Berry and Gina De Jesus move on with their lives after escaping from the imprisonment at the hands of Raul Castro. Thus, while it is often public defenders and those working in nonprofits who have the opportunity to champion civil liberties, it is by no means their exclusive province. One of my most satisfying courtroom experiences was when, as a young lawyer, I had the privilege to represent two women who had been wrongly arrested, manhandled, jailed, and charged with crimes. Their victory in a Section 1983 action against the officers and the city would not have been possible if the Porter Wright law firm for which I worked had not let me try the case on a purely pro bono basis. Some of the civil rights gains that I have mentioned have since been curtailed. Roe has been limited, the Supreme Court has cut back on some of the fundamental aspects of one person, one vote, the role affirmative action once played in education has been restricted, and we have seen a substantial broadening of exceptions to the warrant requirement of the Fourth Amendment. Some see these adjustments as steps backward. Others see them as course corrections. Ultimately, I believe, as did Martin Luther King Jr., that the arc of the moral universe is long, but in the end, bends toward justice. I believe that the legal profession can make sure that the law finds its equilibrium, and that each of you have the chance and the obligation to help that happen, to impact society through the law and through the legal profession. Fundamental issues touching individual rights and liberties still need to be addressed. The rights of gays and lesbians to have their relationships dignified through marriage. The rights of those charged with a crime to be convicted only upon the strength of valid and reliable forensic science. The rights of disabled prisoners to be free of abuse. And the need to balance individual liberties against the security and safety of the nation are only a few of the big questions we face. Now, your role in this will not always be easy. Some causes are particularly unpopular. Those lawyers who challenged segregation in schools and those judges who ultimately outlawed it did so at great risk to their own personal safety. And change does not always come fast enough. Some of the lawyers from Covington and Burling who represented Mr. Korematsu on a pro bono basis in 1944 did not live to see this country apologize and make reparations to those interred over 40 years later. In a chilling example of this reality, despite an active antitrust practice, my brother took time over a 4.5-year period, mostly from his nights and weekends, to represent a mentally handicapped defendant on death row in Texas. He argued unsuccessfully that it was unconstitutionally cruel and unusual punishment to impose the death penalty on mentally handicapped individuals. I recall him telling me how agonizing it was to watch the clock tick to midnight on July 1, 1993, knowing that his client was going to be put to death and the courts had refused to intervene. It would take almost 10 years until 2002 for the Supreme Court to finally decide Atkins v. Virginia and adopt the very position Kevin had espoused years earlier. But none of us went to law school thinking the legal profession would be easy, and no one who graduates from law school can fail to see that the development of the law is neither swift nor linear. History has taught us that it is when attorneys stand to the side and judges bow to the political will that individual rights are abrogated, especially now when the other branches of government are mired in gridlock and when the influence of corporate speech threatens to dilute the voices of individual voters. We need lawyers who care about society and who understand how important their profession is to the continued integrity of our system of government and to the lives of those touched by it. You are now charged with protecting the advances that others have made and remaining open to being the agents of future social change. Whether you do that on a grand scale by taking on a great cause, or even by a smaller one by teaching students the importance of our individual constitutional liberties, I implore you to do it. I know that the education you have received from this institution has prepared you to do it and to do it well. I am proud to be a lawyer and proud to be a member of a profession whose sworn purpose is to defend and protect the Constitution. As you cross this stage to receive your diplomas, I hope you feel the same way. More importantly, I hope you understand the obligations you are accepting along with the parchment you will receive. Congratulations on joining a noble profession. Enjoy your day, and remember to thank your families for all their support and patience, because trust me, you will continue to need it. Thank you.